welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, March 24th, 2025. I have a couple of my Institute for Justice colleagues here who each will present a judicial opinion. In fact, I'm even going to talk about a judicial opinion. So you might think, oh, that sounds like just a normal Short Circuit episode. Okay, fine. Well, the twist is we're all talking about the same case because a couple weeks ago, a case from the 11th Circuit came out with a normal 3-judge panel, but it had an abnormal 4 opinions. And it was talking about so much stuff that checked so many IJ boxes that we decided, you know what, we just got to do the whole thing. Now, all the opinions put together are 169 pages, which is kind of a lot for one opinion. One ruling, 4 opinions. And so we weren't going to do that and then some other case this week or 3 like we sometimes do. So instead, it's going to be all about the one case, which is all about substantive due process. If you ever wanted a show all about substantive due process, this is the right week for you. So we will get to my colleagues in a moment. First, a very quick announcement. So I believe this episode will go out Friday, March 28th, 2025, which means it will be the last episode before our anniversary show on Thursday, April 3rd, 2025 in Washington, D.C. If you are a D.C. area resident and you've been putting off to the last minute to register for this show, it might be too late. I think we're kind of almost in waitlist territory now, and I'm recording this on Monday, so by Friday we might be well past that. But if you're one of these last-minute people, like we've all been there, I get it, and you still want to come, go find the link. I'm not putting in the show notes, but you can find an old episode that we'll have it in the show notes. Go find the link, RSVP. You can probably still come. We always have a few no-shows, so that'll mean that you get on waitlist, even if we are in the waitlist territory. So anyway, don't let it dissuade you, but it is getting pretty full up, and we are so excited to see those of you who will be coming, and those of you who won't be coming and are not so lucky to live in our nation's capital area will nevertheless hear the Short Circuit Live that is being recorded that night. Okay, but for today, substantive due process. I have 2 experts in the area of substantive due process and so many other things with me today. They are Andrew Ward and Diana Simpson. So, are you folks ready to due process?
Let's do it.
Are we going to substantively do it, or is it just going to be a process kind of thing?
You know what? It's all there. It's all included.
Andrew, why aren't you laughing? He's kind of chuckling.
I just didn't know we were coming in with humor. I wasn't prepared for that.
We always come in with humor.
I'll let all of you know Andrew was on mute, which we have taken out, but he was actually laughing at one point, but only after I asked him, why aren't you laughing?
No, post-editing, there's no evidence of that, or that I thought Anthony was funny.
It's kind of a please clap type of situation. And unfortunately, I'm the first one going here, so you can all just clap for me. But I'm going to set the stage. So this case is Little John versus School Board of Leon County, Florida. The case is about a highly controversial subject, and we're not really getting into that. Just to warn everybody, like you're looking for some controversy. We're not really getting into the actual merits of the case and the actual facts of the case. But I will lay them out. Some of you probably heard about it in the news because it's a kind of a big deal when it came out. I'm going to lay out the facts and then set up the ruling of the majority opinion, which is not as interesting as the 2 concurring opinions and the dissenting opinion, but it kind of sets the stage. So, and again, it's all about substantive due process, something that some of our listeners are probably familiar with from past shows and wherever else. Okay, so this is about the family of the Little Johns and their child, who at the time of the events of this case was 13 years old. So here's what happened. Their child was born a girl. The child, I don't know how they knew this. I'm not even sure if it was like a former school and now they went to a new school, or if it was the same school. That's not in the facts of the case. It doesn't really matter. But their child started identifying as a they, them instead of a girl, and wanted to go by a nickname J, like J period, which apparently the child was portraying as a male nickname. The parents had this child in counseling. And so they were, the family was dealing with this situation, whatever other people, may cast aspersions on the situation. The family knew about it and were dealing with it. So the child then started attending school. And I don't know if this isn't part of the story or not, but you can imagine this might be in the background. This is the fall of 2020. And so lots of crazy stuff going on everywhere of the pandemic. This is Florida, so I assume the schools are open, like the child was actually going to the school, but that's what's going on. And then at the school, so that the parents tell the school, our child is going through this gender stuff. We want you to identify our child as a girl, even if our child tells you otherwise. School's okay. So child shows up. They have a policy at the school, though, basically with the background of very understandable history of how LGBTQ kids have been treated when they come out to their families. And so there's something in the policy saying a lot of homeless kids are LGBTQ because they don't have a home to go back to because they came out. And so it's best if you don't tell parents the kid is trying to come out.
And this is a guide that the school board created. So
Yes.
This isn't just kind of like a one-off FAQ. This is created by the board,
adopted by the board, as I understand it. Yeah. So that's the school's policy, and it seems like the counselors at the school, the staff at the school, implement that policy, even though the parents have told them, we want you to do this. So then the child at school says, okay, I don't care what my parents said. I want you to call me a they, them. Although they did let the child use the J nickname, this nickname. Okay, so it goes forward. The child is identifying as another gender at school. And then eventually the parents learn about this. They are not happy. They correspond with the school and one of the counselors, and they basically say, well, we know you told us to not do that, but we did it anyway because something about civil rights laws. And they're like, really? Can you name us the law? And eventually it gets back that they can't really name the law. It actually isn't legally compelled. It's just this is how they do things, and they have this policy too.
Eventually, by the way, means 3-ish weeks, to the extent you think that facts drive the outcomes of opinions. The actual harm inflicted on this was maybe... Is it?
So I missed that.
Yeah. It's at the beginning of the year that the meeting happens, and then the complaint says by mid-September, the parents found out about it. So just throwing that out there, that actual damages might have been $100. So, whatever.
Yeah, we never get the damages in this case. And I'm guessing they would not be very much given those facts. I mean, you can imagine a different situation. Another thing that doesn't go on this case, I should preface before I get a tiny bit of the legal stuff, and then I'm going to turn it over to Andrew. So we've talked about a couple other variations of this situation, which has happened many times across the country the last few years, about schools not telling parents that their kids have transitioned to another gender as they appear at school. The court does not talk about the child's interest versus the parents, right? What is the parents have this right to direct the upbringing of their children, but of course, a child, especially an older child, has some kind of rights too. None of that is apparent in the case, and of course, would be something you would want to think about in the if you actually got into that. So brushing over a lot, we get to how the court then addresses this claim that their rights to guide the upbringing of their child were violated by the school. What do they base that on? Well, there is old precedent, 100 years old now. We've talked about it many times on Short Circuit, that the parents have a right to guide the upbringing of their child and have some kind of familiar privacy right. Meyer versus Nebraska is the first case in this line from 1923. Those old cases were reaffirmed in recent years. I think the biggest, most notable case in recent years was a 2000 case where the grandparent visitation statute was at issue, and the court reaffirmed that there's this fundamental right of parents to guide the upbringing of their children. Now, the trouble is, anyway, I'm skipping over a lot here, but many of you know that substantive due process, the due process clause of the 14th Amendment, as it protects rights that are unenumerated, like the right to guide the upbringing of your child is an unenumerated right. It's not actually like in the Bill of Rights or in the 14th Amendment. That there are some of those rights which are special, and those are, quote, fundamental rights, and they get really high scrutiny. So if the state is going to intrude on that, it needs a really good reason, really good facts. And then there's everything else, which gets almost no protection. That's the rational basis side of things, including what we fight about a lot at IJ, economic liberty. Okay, so which of those two you go into matters a lot. But there's another part of substantive due process that we haven't talked a lot over the years on Short Circuit, and we at IJ don't deal with as much, which is legislative action versus executive. So legislative, that's a normal like statute that you're challenging. And that's usually what constitutional law cases that you've heard about are about. They're about challenges to the constitutionality of a statute. But if the executive, say a governor or a mayor or a police officer, or here, people who work in a school do stuff, right? Executive action. You're not making law, you're like implementing it. You're doing government services. If that is challenged, there's a line of cases that say that's only unconstitutional if it, quote, shocks the conscience. What does that mean? It's really unclear, but it's really hard to prove. So it's kind of like rational basis in a different way. I mean, we could argue which is the harder one. Probably rational basis is harder, but still, shocks the conscience is hard to establish. So here, the question the majority sets up is this executive action or legislative, right? You have staff members just kind of doing stuff like not telling parents and going along with the child wanting to be called a they, them. All right. That kind of seems executive-y. But then you have this policy. That seems legislative-ish, right? It's like words on a page that are adopted by the school board. Well, the court in the end says this is executive, and how it gets there is uninteresting and a bunch of convoluted precedent, especially a very long footnote in this case from the 90s from the Supreme Court called Sacramento versus Lewis, which was about a high-speed chase, very different type of situation. So all you need to remember is there's all these arguments on one side for why executive action should be treated in this shocks the conscience way. But then there's arguments on the other side that this is a fundamental right. So what happens when you have a fundamental right in the executive sphere, right? Is it still the same as it would be for challenging a law? Is it strict scrutiny? Or is it shocks the conscience, even if it's a fundamental right? And they say it shocks the conscience, even if. And so the family easily loses because this doesn't shock the conscience, because they give these other cases in the case law about shocking the conscience in kids at school. And basically, even if a child dies because the school did something bad, that might not even shock the conscience. So good luck with your 3 weeks and your, gender names. And that's how the court says that. 2 judges in the majority, but behind the scenes, the judges don't agree on a lot else. And that's where Andrew Ward comes in.
Well, hang on, because you said it was uninteresting how they get to executive. But this is crucial, right? Because if it's executive action, it's the shocks the conscience test. They ultimately decide, which, you can't meet. But if it had been legislative, then it would need to go through strict scrutiny. Which would be a much, much more complicated decision.
There's all kinds of minefields.
You would have to decide whether having this sort of policy about gender identity at school is a violation of parental rights. Does it, does the right go that far? Are there compelling reasons to have it?
Does it even apply in public school?
Right. And one thing they say, because there's this guidebook that, like, there was a policy that was enacted, is not quite the right verb, but almost, by the school board, that this isn't legislative because the plaintiffs waived their challenge to it being legislative. And that is, I was once a clerk in a federal court looking for ways to make things simpler. And if you go and look at where the purported waiver is, I don't think it sounds anything like a waiver of that argument. While the case was going on, the school board passed a different policy. They got rid of this one. And so then there was an argument that the case was moot. In the passage, purportedly where the plaintiff appellants waive their challenge to this being legislative action, here's what they say, responding to the idea that the case is moot. And what they say is, defendants' approval of a new guidance document does not absolve them of the consequences of their violations of plaintiffs' rights in 2020 and as 2021. Plaintiffs are not seeking prospective relief from their gripes about the 2018 guidance. They're seeking a declaration that their constitutional rights were violated. Defendants acted in accordance with the 2018 guidance when they violated the plaintiff's constitutional rights. But it's defendants' course of conduct, not the contents of the 2018 guide, that is the focus of plaintiffs' action.
That's not waiver.
They're contrasting it with the new thing that was put into place to say that their case isn't moot. They're not saying that they waive it being legislative, and that is extremely important to the disposition of this opinion, and that's an awful lot hinging on the one sentence. So I'm just throwing that out there, but I'm here to talk about substantive due process, and I've led us astray.
Well, side note to that, I think, yes, the court is manufacturing a waiver, it sounds like, and probably all of us on this podcast have been through similar, I know Diana has with me, similar cases where the court manufactures a waiver where there wasn't a waiver. But like, I don't fault these attorneys at all. I really don't. But if you're being absolute belt and suspenders as a practitioner, is that a place where you'd have a footnote and say, this does not waive our, blah, 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 blah.
Well, yeah, because you include that footnote because it's happened to you before. Who knows? Maybe these attorneys hadn't been like bludgeoned on the side of the head by a clerk trying to find the easy way out, Andrew.
Right. I mean, if it wasn't for that, it might have been something else. So I'm not faulting them. But
although that fact, I think, is an interesting fact and about the mootness. And so, like, to the extent that, this 3-week window was the issue, the mootness is also really interesting because in 2021, Florida enacted the Parents' Bill of Rights that basically said, all right, you can't get in the way of parents and the upbringing of their kids. And so the school board updated its guide to say now that school personnel cannot intentionally withhold information from parents unless a reasonable person would think that that disclosure would result in abuse or neglect. And so this can't happen again in the same way. And so to the extent that a judge is a human and is looking at a case and saying, okay, well, this problem can't arise again, so let's look at this case kind of just on the narrow island of its own facts.
Yeah, I mean, cases are live if like $1 is in play. But again, if you think that facts influence the way cases get decided, this might have not been the case for like 21 amicus states plus the Manhattan Institute but anyway, I'm here to talk about substantive due process. So, what's going on with that? The background is basically that Judge Newsom, who's on this panel, doesn't like substantive due process. I actually think more broadly, he just doesn't like unenumerated rights. It's not entirely clear, but he hates substantive due process. He thinks it's made up. He correctly, of course, points out that substantive process is an oxymoron that, was meant to be pejorative. And he's had like 3 long concurrences in various 11th Circuit opinions saying that, substantive due process is terrible. And Judge Rosenbaum thinks Robin Rosenbaum thinks it is finally time to respond.
This is her chance. Get back.
Yeah. She has a cool footnote that was like, I actually had a chance before, but I was busy explaining why the majority was wrong, so I couldn't do it then, which, yeah, man, you go, girl. So this is basically, as Judge Newsom calls it, an ode to substantive due process. It's Judge Rosenbaum's like 70 or 80 something page defense of substantive due process, and she basically goes through and says a lot of stuff that is music to my IJ ears. I think she gets a couple particulars wrong, but it's basically sort of this great tribute to unenumerated rights. Like, look, of course they exist. That's what the Ninth Amendment says, and we have always done this. We did this in common law England, at least some. In as soon as the Constitution was enacted, we were saying there were things the government just couldn't do, even if it wasn't something listed in the Bill of Rights. You can go back to something like Calder versus Bull. You can't take property from A just to give it to B, which is not grammatically in the Public Use Clause, but it is true nonetheless. And she says that there's this huge long history. This is the way we've always done it. And ultimately, we're not really fighting about very much, because Judge Newsom's preferred way of dealing with this would be to house rights in the 14th Amendment's Privileges or Immunities Clause, long neglected since the slaughterhouse cases, and not the Due Process Clause. And she basically says, we would have these huge regimes build up either way. There's really not much difference, but there have always been unenumerated rights. We have them. It's a good thing. And Judge Newsom is wrong. Now, there is a note that I don't think gets mentioned, although I'm not sure because this is 169 pages long, that the Privileges or Immunities Clause applies to citizens, whereas the Due Process Clause applies to everybody. So there could someday be some difference there. And she goes on to say that in her estimation, our modern tiers of scrutiny basically does approximate this historical understanding, and the way we deal with unenumerated rights now actually accords pretty well with the common law tradition, which is like mostly, I think, probably right, although she's a little too casual about the rational basis test, which actually means more of like plaintiffs never ever win unless you're IJ occasionally. Whereas she says it's like this, low thing that's still a test, and we could.
If it were the test of
that.
Cleburne, then I think I would agree with her. But if it's the test of FCC v. Beach, then I don't agree with her.
Well, she cites both.
I know.
As if they were the same thing.
She also has some not nice things to say about economic liberty.
Yeah, so that's definitely the worst part of the opinion, that she goes on to say that some of the bugaboos of substantive due process, shouldn't be taken as a criticism of the entire doctrine, like Dred Scott, which is very little to do with substantive due process. I think that's right. And also like Lochner, which is this hated decision, but you shouldn't throw out the baby with the bathwater. And she gets some things wrong there about economic rights, just like not being subject to the political process. And those totally, you wouldn't have abuse the same way you would for personal privacy rights. That's just totally wrong, as proven by IJ's entire existence. But I will say overall, I think the concurrence is more right than wrong. She's especially right about unenumerated rights as opposed to substantive due process, right? That there clearly is a tradition of that. The Ninth Amendment clearly protects it, and there's probably not too much difference depending on where those get housed. There is some originalist defense. People disagree about there actually being textual grounding in the Due Process Clause itself, because the idea of due process of law, it's not the process part, it's the law part. And the whole idea that the law needed to be the law of the land, which had certain substantive elements going back to Magna Carta. But she's definitely right that unenumerated rights are real, they're good, and they should be there. Especially whether you consider them substantive due process or not. Judge Newsom's real thing, I think, if you go back and look at the law review article by Judge Newsom that he cites, he really seems to think that there shouldn't be unenumerated rights at all. He doesn't say that. He says it's a question for another day, but he clearly seems to think there shouldn't be any. That's the bigger problem. Maybe he's kind of right about substantive due process, maybe not. But Judge Rosenbaum is definitely right that unenumerated rights are real. They're good. I think she's the winner of the concurrence fight. I think perhaps the even bigger winner is Orrin Kerr, who says these sorts of things should be in law reviews and not concurrences, but whatever. Anyway.
But then we couldn't do a podcast about them all. I mean, we're not going to have like 3 law review articles. Are we going to do that? Start doing that?
I mean,
There's an infinite limit of podcasts, right?
Our audience could go down to single digits, but it would.
I don't know if my mom would listen to that one.
Anyway, it's a good concurrence. She's right about unenumerated rights. She gets some things wrong about economic liberty and the rational basis test, but more good than bad. And yeah, that's what Judge Rosenbaum thinks.
Diana, do you have thoughts about Judge Rosenbaum before we move?
I mean, I look, to the extent that substantive due process is the world in which we live, then okay. Let's have it. You know, I'm, I think, a little more optimistic about privileges or immunities, and I think that it is likelier that that would be a more protective test, but it's not. So
maybe, but I mean, it's not like where we see these differences. It's not making a difference, right? Like the Second Amendment seems to have maybe been incorporated under the privileges or immunities clause instead of the due process clause. And it's all, you know, it's not mattering too much these days.
I mean, is it? It's the Second Amendment is like one of the most robust pieces of the Bill of Rights right now, in a way that like the First Amendment had its heyday, and it's, you know, it's still strong. I'm not suggesting otherwise, but like the Second Amendment is like getting bolstered, and it's getting stronger.
That is definitely factually true, but I think it's a coincidence.
Well,
I mean, maybe.
I think Andrew's point is it's not because it was that one of the 5 votes that incorporated it, quote unquote, in Justice Thomas's opinion in McDonald was under privileges or immunities clause. Like that has not changed subsequent Second Amendment case law.
No, of course that's you know, that's an enumerated right. So I really don't think PRI versus due process is going to make a difference for the enumerated rights. Yeah. But maybe it would for the unenumerated ones. Overturned Slaughterhouse. Judge
Newsom's law review article from 2000, when he was a young associate, so it was out of law school, but he was still private practice, did read a little bit of it, and it's really all about incorporation. Like there's nothing that he says slaughterhouse cases were good because there's room for incorporation in them. And so, and of course, what that means is, okay, you have incorporation, but you would not have economic liberty because that's what the dissent said in Slaughterhouse. And that's basically the view that, say, some other people like Kurt Lash have, that Slaughterhouse was okay because it left room for incorporation. It was later in this case called Cruikshank that the court really said that the PRI clause has no meaning.
And Judge Newsom's criticism, like, clearly imply he doesn't believe in anything unenumerated, right? Yeah. Like, if it's not in the text, it'll just be freewheeling. Well, I mean,
I don't know.
Policy.
Has he done a concurrence about the Ninth Amendment? You know, maybe he'd think differently with that.
He should come on this podcast and let us know what he thinks.
Well, we'll see if we hear from him. I will say I'm going to leave till later. I have some criticisms of the anti-economic liberty part of Judge Rosenbaum's opinion, but I will say that there's this argument that if you're an originalist, that the due process clause, like you guys were talking about a little bit ago, it actually does have substantive protection because you should read it as people understood it when the 14th Amendment was adopted or the 5th Amendment was adopted, not as we would today where you just see the word process and think, well, that means process. And if you're being a good originalist, there's good arguments that like it was kind of a term of art of how it were read to protect substantive rights at that time, at least to some extent. And the best piece on this is Ryan Williams, which Judge Rosenbaum cites in a good way, the one and only substantive due process clause, where he argues that that's true for the 14th Amendment, but it actually wasn't true back for the 5th Amendment. Anyway, and I think Judge Newsom tangled with a little of that in one of his older concurrences. I can't remember, but anyway, you don't want to give the game away that, yes, if we're being good originalists, there is no protection for unenumerated rights under due process clause. Like that's not at all an authoritative view.
You know, while we're here, isn't Dobbs just like a huge argument in favor of substantive due process? Because really everybody's problem with substantive due process is that it led to Roe, but now it didn't lead to Roe anymore, which means like the best argument against it went away.
You could make that argument.
If you take the argument that like your problem with unenumerated rights is that they lead to Roe, well, now in 2025 they don't. So your best counter argument is gone.
Okay, but there's other kind of controversial to some cases of the Supreme Court resting on substantive due process.
True, but that was the most controversial.
Like raising your children.
Yeah, and teaching them German.
Yeah.
Indeed. Well, not everyone agrees, though, with Judge Rosenbaum. And so we're going to skip all the way down to the dissents now, which Diana will enlighten us on.
Yeah, so Judge Joe Flatt has a dissent, and he is on fire. And so just as a point of order, Judge Joe Flatt isn't he the last of the Carter appointees?
He's a Ford appointee.
Oh gosh, a Ford appointee.
He was put on the Fifth Circuit by Ford 75, and then when they rejiggered and then made the 11th Circuit, he got moved over there.
Is he the only living judge that has transferred circuits by way of? He must be, right? By way of a circuit, like giving birth to another circuit mitosis.
Well, it would only be other 11th Circuit judges.
Yeah.
Yeah. Well, let me look up senior judges. Judge Lainer Anderson III was on the Fifth Circuit before it was split, 79. And just those two.
So Judge Joe Flatt, like his whole thing here is that he's totally does not buy this executive versus legislative action and the different standards. And that, because basically, if it's legislative, then you get the real kind of standard, typical substantive due process test. And if it's a fundamental right, you get strict scrutiny and the government has a whole lot of work to do. But if it's executive, you don't get anything. You just get the shocks the conscience standard, which in the majority opinion they go through. And basically the only way a parent has a substantive due process right over their kid with executive action is if the school deliberately, or a school official or a school employee deliberately inflicts harm on a child. Not just reckless indifference where a child dies because they didn't get enough water during football practice, but like beats the child so that their eye falls out and they become blind. Like that's one of the two cases they cite. And that's the world that the shocks the conscience standard lives in the 11th Circuit. And Joe Flatt just does not buy that. That is totally not how the Supreme Court case law has developed, and that there isn't this distinction between executive and legislative, that it's the same, basically all the same test applies. And so if you have a fundamental right, which is what you have here, everyone agrees, or at least arguendo agrees, that there is a fundamental right, to direct the upbringing of your child. And so once you've established that, then you are onto the world of, okay, now we're in the real test land where the government has a lot of work to do, and let's do that. And so to get there, he goes through and talks about the Supreme Court case that establishes this, and not just the one. There's several of them. There's Salerno. There's all of them really. But so he goes through them and he talks about them, and it's not at all the way that the majority describes the test, I don't think. And there's this big fight over the word or, and there's a big fight over a footnote. And if all you're coming down to is a fight over whether they use the word or and then a fight over text and a footnote, isn't that shouldn't like you come back 30,000 feet and say, you know what, that actually is a problem, that's where we're seeing these lines be drawn. Like that to me is, I think, a big deal. And that was a big deal to Joe Flatt too, or is a big deal to Joe Flatt. In Salerno, they say that the substantive due process prevents the government from engaging in conduct that shocks the conscience or interferes with rights implicit in the concept of ordered liberty. And so this disjunctive framing is that kind of the difference. Is that really where this whole line of cases should come out? And that, if you're challenging an executive action, you have to prove that it shocks the conscience, which you're basically never going to do unless you get a rogue government official just beating you upside the head. To me, when it comes down to just the word or a footnote, that's tough. And that's what Joe Flatt spends a lot of time talking about.
Yeah, the majority, I think, probably is the better read of precedent, but Judge Joe Flatt definitely has the right ideas from 30,000 feet. Like, it probably shouldn't matter if the government violates your constitutional rights through executive action or through legislative action, because both are unconstitutional.
Well, and it seems like he has a pretty good argument that this whole shocks the conscience test through the prism of a police chase case, Sacramento versus Lewis, means that really only works when you have like a police action type of situation, not where you have executive. I mean, it's a little bit mirrors the argument we have about qualified immunity and split second decisions, right? That it's really people are thinking about that type of situation. But if you have school officials, who have a few weeks with a child to do whatever they're doing, that's not the same as a high-speed chase.
I think that's right. Although some of the stuff he cites in support of that point is like a case cannot decide anything beyond its facts ever, which is maybe a little extreme. We might need to up the size of the federal judiciary a little bit if that's true.
Very formalist approach to dicta.
Yeah, it does. I like how there's a heading. One of the headings within the opinion is orbital dicta. You usually don't have someone use that entire phrase when you're talking about dicta.
I mean, but that's what the fight is, right? The fight is about, I'm surprised there's not a section heading in disjunctive framing. The facts are really, like in all of these cases, right? You have split-second decision-making where the cops are chasing after a motorcycle and they're going 100 miles an hour in a residential zone. That's the Sacramento case. And then you've got the origin of the shocks the conscience phrase, which is from a case where the government forcibly pumped a defendant's stomach to search for drugs and then used the materials to convict him of for crimes related to those drugs. And so that's a case called Roisin from 1952. And so you have like this series of how long does it take to make a decision? And then you've got a guidebook published by put out by the school board. And so presumably they spent a lot of man hours figuring out what the right way to address this guidebook was and a lot of attorney time. And so there's no automatic decision making, no tough decision making in close quarters where you have to worry about whether you're going to get shot or killed or run over an innocent person or something like that.
And then there's a Newsom concurrence.
So Diana, that's the lay of the land.
Yeah, I mean, he basically just goes through the history of the shocks the conscience standard, where it came from, where it kind of cropped up, and that he doesn't think it was meant to be a separate test. He doesn't think it's meant to be this whole, other universe where, plaintiffs always lose unless there's intentional, infliction of substantial harm or whatever. And then he goes through and says that all of this other stuff you guys have from the Supreme Court is wrong. And then he looks at the 11th Circuit decision, Maddox, that is supposedly binding precedent. Supposedly it is binding precedent on future panels unless they go en banc. And he says that it doesn't apply in the same fashion. I'll be curious to see if there's an en banc petition filed. And nothing has happened on the docket since the opinion issued.
Yes, as of the day we're recording this, but
yep.
More
as of about half
an
hour before we started recording.
And I would not be surprised if this is a case where a judge asks for a poll for rehearing, which they can do without anyone filing anything. Which brings us to concurrence number 2. So this is Judge Newsom's, as we were saying, latest concurrence on substantive due process. Andrew has already covered an overview of his past ones, which are more about why using it to protect unenumerated rights is bad. And so we at IJ mostly disagree with those. But this one, I got to say, he has some really good points because he outlines this whole bifurcation between legislative action and executive action. And we can dispose of his concurrence pretty quickly here because he says, it's kind of weird that if you have this right and it's a legislative restriction and it's one of these unenumerated fundamental rights, like the right to raise your children, that you get strict scrutiny. So you probably win. But if it's executive, which there can be a gray area between the two, if it's executive, then you're probably going to lose because shocks the conscience is hard. And so he lays out that all of that. And then he says, that makes no, N-O in italics, sense. It makes no sense. And he's absolutely right. It makes no sense that you would treat actions by the government in one respect subject to this crazy different standard than another when you're talking about the same right and you're talking about the same thing, which is the government. And he points out that the Fifth Amendment is written passively, so it's about all government action, and the Fourth Amendment just says no state, right? It's just all the branches of state government. So very good point there. He lays it all out, and he's bound by precedent, which we understand. And would that be something that the Supreme Court would reconsider in the future? Probably not the current Supreme Court, because they don't seem too excited about substantive due process in the first place. But he makes very good points nonetheless. So I want to circle back, though, to the Judge Rosenbaum's concurrence and something that she discussed when she starts going all, Lochner is bad. And that's, she cites a book that came out just a few years ago called Constructing Basic Liberties, a Defense of Substantive Due Process, which was by a Boston University law professor, James Fleming. I haven't read the entire book, but I've read a lot of it. And he is a very passionate defender of protecting unenumerated rights through substantive due process. So there's a lot that I agree with in the book. But it is also, I think it's just like encapsulates the gymnastics that kind of modern legal academy and much of the modern judiciary have gone through the last few decades to try to protect rights they like and then not protect unenumerated rights they're not so into, like economic liberty and property rights. And so we've discussed in past episodes, I'm sure many times, about how the Supreme Court over the years has said, there's these non-fundamental liberties like economic liberty, and they're just different than liberties we are going to protect, like, say, raising your children or procreation, or right to travel is another one that comes up. There's a handful of others. Abortion, of course, used to be there, but isn't anymore. And so the distinction between those is always really kind of hazy. And every defense I see for it doesn't make a lot of sense. Anyway, Professor Fleming really tries to go at this issue, and I hand it to him. But in the chapter where he does this in this book, it's like he takes these arguments to their logical conclusion, and then you can see how they really don't have anything there. And it's what he says is, yes, actually, those are fundamental rights. So your right to economic liberty, that is a fundamental right. You're right. How can you have a fulfilling life in America if you don't have the right to, say, engage in economic transactions or to try to pick your profession or whatever? So you're reading it, like if you're an IJ type person, you're reading it, you're like, yeah, exactly. And then he says, but those fundamental rights don't need protection through substantive due process because they're protected through the political process.
Which is to say, not protected at all.
Not protected at all, of course. And he doesn't say anything about public choice theory or, concentrated benefits and dispersed costs or cartels or lobbying the legislature. It's like, nothing's changed since Caroline Products in 1938.
It's people, Frankfurter-esque judges, right? They're often, they talk about, well, judges don't have the expertise to figure out which economic regulations are, so unwise as to be irrational. I'll tell you what judges actually don't have the expertise to do, which is figure out like which people are protected in the political process.
It seems, because then he doesn't go very deep into this, but then he says, you know what? Someone's going to say the counterexample to all of what I'm saying right now, which, remember, is a book about substantive due process, is the Kelo case. So he actually says this. Kelo, they took that lady's home and it was really bad. And I agree. But you know what? The political process fixed that, because then all these states changed their laws. So it proves my point. And we don't need to go through all the details of why it doesn't prove his point. And still plenty of people are hurt by eminent domain. And, a lot of people, even in states where laws have changed, are needlessly harmed, and how that all only happened because places like IJ made it happen and had a communications team to make it happen. But yeah, that's the argument. So after reading that, if you've ever wondered, is there something I'm missing here about why economic liberty is different than other personal liberties, and maybe these judges have a point? No, there is no point. It convinced me of the bankruptcy of that argument, and I still have not read anything that convinces me otherwise.
My lesson from all of that is never put your faith in politicians at all. But
yeah,
that's been my kind of guiding principle for a while.
So anyway, I think that's kind of what's going on in that part of Judge Rosenbaum's concurrence, and it just has one citation to Professor Fleming's book, but there's some citations to other stuff in cases that have made similar points. And so if you're out there and you're thinking, is there a difference between economic liberties and other personal liberties that makes sense under the Constitution? No, there is not. And you should check out why that is. So that brings us to the end of this four-part opinion. Is it an opinion? It's 4 opinions. Case, ruling. 4 opinions in a ruling, and we'll see what happens. But as we said, it might go en banc from here, or perhaps even because of the subject matter to the Supreme Court. But I do not see the Supreme Court second guessing this substantive due process distinction in the future.
Although I believe there is a circuit split on these, so who knows?
Yeah, they got into that in the majority opinion. The First Circuit it would have come out quite differently than the 11th Circuit.
Yeah. Well, thank you guys for coming on. This is a new format we have here on Short Circuit. Maybe the next time we have a 169-page set of opinions that checks a lot of IJ boxes, we'll have you back and try to do it again.
Thank you, Anthony.
Yeah, I'd love to come back.
But until next time, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.